What will happen when you are arrested in flagrante delicto while doing an illegal act in the Philippines?
In today's video, we will be learning what will happen to you if you are arrested by a police officer without a warrant doing an illegal act. What processes will you have to undergo before you can go out of detention, or will you ever get out of prison legally? I will introduce the jurisdictions of the court so that you will have a basic understanding.
If you like to know, watch this short video discussion and subscribe for more useful information. Comment your legal questions and we will answer.
To answer the question earlier, let me first discuss in layman's term the jurisdiction of courts in relation to criminal cases in the Philippines. Jurisdiction is important because filing case in a wrong court can mean dismissal of the case. Let me start only with the basic ones. We have the Municipal Trial Court, MTC, Metropolitan Trial Court, MTC, Municipal Trial Court in Cities, MTCC, and the Municipal Circuit Trial Court, MCTC, which have jurisdiction for felonies and offenses with penalty of imprisonment of less than 6 years, including cases involving summary procedure. On the other hand, the Regional Trial Court have jurisdiction for cases with penalty of imprisonment of more than 6 years. Crimes and offenses with penalty of imprisonment of at least 4 years, 2 months and 1 day are required to undergo a preliminary investigation to be conducted by a public prosecutor.
Preliminary investigation is an inquiry or proceeding to determine whether there is sufficient ground to engender a well-founded belief that a crime has been committed and the respondent is probably guilty thereof, and should be held for trial.
Let us go back to the highlighted question. What will happen when you are arrested in flagrante delicto while doing an illegal act in the Philippines?
Answer.
It will depend on what kind of felony or crime was performed or omitted. There are different rules that apply as to different felony or crime performed. Say for example, you were caught by police officers while you are performing the act of burning an inhabited house. The felony committed is arson with penalty of reclusion temporal to reclusion perpetua or 12 years and 1 day to 20 years.
As such, the suspect will undergo inquest proceeding and the suspect will be given a choice whether he will undergo preliminary investigation or not. If he avails of the preliminary investigation, he will sign waiver of the provisions of the Article 125 of the Revised Penal Code, RPC, together with a lawyer of his own choice. If does not avail of preliminary investigation, then the inquest proceeding will be finished within the time provided for in Article 125 of the RPC.
This will be elaborated further in this video. Note: in flagrante delicto means in the very act of wrongdoing.
This will now be the sequence of events if you are caught in flagrante delicto burning an inhabited house. 1. The police officer will freeze or restrain the suspect. 2. The officer will make proper introduction as to identity and authority to arrest. 3. Inform the arrested person of the circumstances of his arrest and recite the Miranda warning and anti-torture warning to him. 4. Secure the person to be arrested and use handcuffs for the protection of the arresting officer, other individuals or the arrested person himself. 5. Conduct thorough search for weapons and other illegal materials on the person arrested and surroundings within his immediate control. 6. Confiscated evidence shall be properly documented with the chain of custody of evidence duly and clearly established. 7. No unnecessary force shall be used in making an arrest. And 8. Bring the arrested person to the police station for further investigation and disposition. 9. Within the periods provided by the Article 125 of the Revised Penal Code, an inquest proceeding will be performed by an inquest prosecutor.
Inquest is an informal and summary investigation conducted by a public prosecutor in criminal cases involving persons arrested and detained without the benefit of a warrant of arrest issued by the court for the purpose of determining whether or not said persons should remain under custody and correspondingly be charged in court.
Article 125 of the Revised Penal Code provides that The penalties provided in the next preceding article shall be imposed upon the public officer or employee who shall detain any person for some legal ground and shall fail to deliver such person to the proper judicial authorities within the period of 12 hours, for crimes or offences punishable by light penalties, or their equivalent. 18 hours, for crimes or offences punishable by correctional penalties, or their equivalent, and 36 hours, for crimes or offences punishable by afflictive or capital penalties, or their equivalent. In every case, the person detained shall be informed of the cause of his detention and shall be allowed, upon his request, to communicate and confer at any time with his attorney or counsel. In this given problem, the police officers must be able to deliver the detained person to the proper judicial authorities within 36 hours after arresting the suspect.
1. By the time of the arrest, the suspect may avail himself bail. Temporary release pending the court trial of the suspect or accused. This is in line with the constitutional right provided in our 1987 Constitution, which states that the accused shall be presumed innocent until the contrary is proved, and shall enjoy the right to be heard by himself and counsel, to be informed of the nature and cause of the accusation against him, to have a speedy, impartial, and public trial, to meet the witnesses face to face, and to have compulsory process to secure the attendance of witnesses and the production of evidence in his behalf.
Rule 114 of Section 4 of the Rules of Criminal Procedure provides, all persons in custody shall be admitted to bail as a matter of right, with sufficient sureties, or released on recognize as prescribed by law or this rule. Before or after conviction by the Metropolitan Trial Court, Municipal Trial Court in cities, or Municipal Circuit Trial Court, and b. Before conviction by the Regional Trial Court of an offense not punishable by death, reclusion perpetua, or life imprisonment.
Since, in our example, the suspect committed arson, which is punishable with reclusion temporal or with a period of 12 years and 1 day to 20 years.
1. The inquest proceedings shall be considered commenced upon receipt by the inquest prosecutor of the following documents from the police officers. A. The affidavit of arrest duly subscribed and sworn to before him by the arresting officer. B. The investigation report. C. The sworn statements of the complainant, S, and witness, S, and D. Other supporting pieces of evidence gathered by the police in the course of the latter's investigation of the criminal incident involving the arrested or detained person.
When the documents presented are not complete to establish probable cause, the inquest prosecutor shall direct the law enforcement authorities to submit in the proper form the required evidence within the period prescribed under the provisions of Article 125 of the Revised Penal Code, as amended. Failure to submit the required evidence within the periods prescribed shall constrain the inquest prosecutor to order the release of the detained person. 1-2. The inquest prosecutor will determine the validity of the warrantless arrest. Should the inquest prosecutor find that the arrest was not made in accordance with the aforesaid provisions of the revised rules on criminal procedure, he shall recommend the release of the person arrested or detained. 13. Should the inquest prosecutor find that the arrest was properly effected, the detained person shall be asked if he desires to avail himself of a preliminary investigation and, if he does, the consequences thereof must be explained to him adequately. The detained person, with the assistance of a lawyer of his own choice, shall then be made to execute a waiver of the provisions of Article 125 of the Revised Penal Code, as amended. The preliminary investigation may be conducted by the inquest prosecutor himself or by any other prosecutor to whom the case may be assigned by the chief state prosecutor or the provincial, city prosecutor, which investigation shall be terminated within 15 days from its inception. 1-4. Where the detained person does not opt for a preliminary investigation or otherwise refuses to execute the required waiver, the inquest prosecutor shall proceed with the conduct of the inquest proceeding, notwithstanding the absence of a counsel, by examining the sworn statements, affidavits of the complainant and the witnesses and other supporting evidence submitted. If the inquest prosecutor finds that probable cause exists, he shall forthwith prepare the resolution with the corresponding complaint, information with the recommendation that the same be filed in court. The complaint information shall indicate the offence committed and the amount of bail recommended, if applicable. If the inquest prosecutor finds no probable cause to indict the arrested, detained person, he shall recommend the release of the arrested or detained person. 1.5. In our example, the prosecutor will file the case in the regional trial court because the penalty of destructive arson under Article 320 of the Revised Penal Code is reclusion temporal or 12 years and 1 day to 20 years to reclusion perpetua. 1.6. The regional trial court now releases an order for you to be arraigned. Rule 116, Section 1 of the Rules of Criminal Procedure provides that the accused must be arraigned before the court where the complaint or information was filed or assigned for trial. The arraignment shall be made in open court by the judge or clerk by furnishing the accused with a copy of the complaint or information, reading the same in the language or dialect known to him, and asking him whether he pleads guilty or not guilty. The prosecution may call at the trial witnesses other than those named in the complaint or information. The procedure in court will now be tackled in another video as it is already very long discussion. I hope you learned something new today. Comment your questions and we will answer them. Sources used: 1. PNP Manual of Operations, and 2. Prosecutors Manual of Operations. For more useful information about the Philippine law and jurisprudence, subscribe.